In California, the line between a legal demand and criminal extortion is much thinner than most people think. In a place like San Jose and the broader Santa Clara County, where business disputes, tech competition, and high-value negotiations are common, that line is crossed more often than expected. Situations that seem routine can quickly turn into criminal cases. A demand letter asking for payment while threatening exposure of wrongdoing. A severance negotiation where one party references sensitive information. A business dispute where someone threatens to go public unless money is paid. All of these can potentially lead to extortion charges under California Penal Code 518. Because of Silicon Valley's aggressive business culture, these cases are especially complex. What one person sees as a legitimate negotiation tactic, law enforcement may view as a criminal threat. What is extortion under California law? Under Penal Code 518, extortion occurs when someone obtains money, property, or an official act through the wrongful use of force or fear. The key word here is wrongful. Not every threat is illegal. The law focuses on whether the threat was used improperly. What counts as a threat? California law recognizes three main types of threats that can lead to extortion charges. 1. Threats of harm. This includes physical injury, property damage, or harm to someone close to the victim. 2. Threats to accuse someone of a crime common in disputes where one party claims illegal activity. 3. Threats to expose a secret, especially relevant in business or personal disputes where reputation is at risk. In San Jose, the third category, threatening to expose damaging information, is one of the most common. The legitimate claim defense. Not every demand involving a threat is extortion. California law allows what's called the legitimate claim defense. This means if you had a good faith belief that your claim was valid, your actions may not be criminal. For example, threatening to file a lawsuit to recover a real debt, reporting workplace misconduct unless it's resolved, negotiating a settlement based on actual wrongdoing. These are generally legal as long as the claim is genuine, the demand is reasonable, the threat is connected to a lawful right. The line is crossed when there is no real legal basis for the claim, the demand is clearly excessive or unrelated, the threat is used purely to pressure someone into paying. Why extortion cases are common in Silicon Valley. Santa Clara County has unique factors that lead to more extortion allegations. High-stakes business disputes, frequent use of end-us and confidential data, competitive tech environments, workplace conflicts involving sensitive information. Common scenarios include employees threatening to expose company misconduct, disputes over intellectual property or trade secrets, conflicts involving non-disclosure agreements, online threats involving personal or private content. In many of these cases, the difference between lawful negotiation and extortion is heavily disputed. What the prosecution must prove. To convict someone of extortion, prosecutors must prove 1. A threat was made. 2. The threat was intended to obtain money, property, or action. 3. The threat was communicated to the victim. 4. The victim complied. For full extortion charges, if the victim did not comply, the case may be charged as attempted extortion under PC 524. Penalties for extortion. Extortion under PC 518 is a felony in California. Penalties include 2, 3, or 4 years in state prison. Related charges. Attempted extortion, PC 524, can be a misdemeanor or felony. Written extortion, PC 523, emails, texts, or letters, also a felony. Because most communication today is digital, written evidence often plays a major role in these cases. How these cases are investigated. In Santa Clara County, extortion cases are usually built on digital evidence, including emails, text messages, Slack or workplace chats, social media messages, recorded phone calls. Police may also ask the alleged victim to record future conversations, monitor communications after a report is made. Additionally, investigators often examine the relationship between both parties, especially in business or employment disputes. Common types of extortion cases. 1. Workplace disputes. Employees or employers may threaten to expose misconduct during severance or settlement negotiations. The key issue is whether the claim is legitimate and the demand reasonable. 2. NDA and confidential information cases. Threatening to release confidential information in exchange for money can lead to charges, especially if the information is protected and the demand lacks legal basis. 3. Online extortion, sextortion. This involves threats to release private or intimate images unless money or further content is provided. These cases are prosecuted aggressively. 4. Business and IP disputes. Companies or individuals may threaten legal action or exposure related to patents or trade secrets. These cases often hinge on whether the underlying claim is valid. Defense strategies. A strong defense focuses on challenging the idea that the conduct was wrongful. Legitimate claim defense. Showing that the demand was based on a real legal right or dispute. Lack of intent. Not every aggressive statement is extortion. The prosecution must prove specific intent to obtain something through a threat. Context matters. Messages can be taken out of context. A full review of all communications often changes how the situation appears. Free speech and legal protections. Certain communications like legal demand letters may be protected under the law. What to do if you're accused? If you're facing an extortion allegation in San Jose, stop all communication with the other party immediately. Save all messages and records. Context is critical. Gather evidence supporting your claim, contracts, emails, etc. Do not speak to police without legal counsel. Early legal intervention can make a major difference, especially before charges are officially filed. Key questions people ask. Is it extortion to threaten legal action? No, if the claim is legitimate and made in good faith. What's the difference between extortion and attempted extortion? Extortion requires the victim to comply. Attempted extortion applies when they don't. Can a demand letter be illegal? Yes, if it includes threats unrelated to a legal claim or is used purely to pressure payment. Can extortion charges be removed from your record? In some cases, yes, especially if probation is granted and completed. Final thoughts. Extortion cases in San Jose are rarely simple. They often sit in a gray area between aggressive negotiation and criminal conduct. What matters most is intent, context, and whether there was a legitimate legal claim behind the demand. If you're involved in a dispute where threats, demands, or sensitive information are part of the conversation, it's critical to understand where the legal boundaries are before things escalate. If you found this helpful and want more simple breakdowns of complex legal topics, make sure to follow and stay updated. And if you or someone you know is dealing with an extortion accusation or a high-stakes dispute, don't wait. Getting the right legal guidance early can completely change the outcome.